are very lucky to have our special guest here, Peter Mennen, who is ex-TPN and an expert on all things property legal. So I'm extremely grateful that you are joining us here today and imparting your knowledge onto us. So thank you for your time. I do appreciate it.
Angela, that's an upsell, not a downsell.
I try my best. So I'm not going to delay this any further. If you would like to go ahead and let's get the show on the road. Thank you so much.
Perfect. Thank you very much, Angela. First of all, thank you very much for inviting me for today. I apologize. As you can see, I'm in short shirts. Like Angela said, I recently left TPN and I'm starting another position on the 1st of April. So until that time, I'm actually at home, which is fantastic. I haven't had a long holiday in quite a while. So I feel very well rested, let's put it that way, but I haven't done training in around about 3 or 4 weeks. So I apologize if my language use is not the same as what you're used to on the normal webinars that I do present. But I'm going to try to get through this as succinctly as possible with you today. I know there's been a lot of questions regarding the Act, its implementation, who it applies to, and what you sort of need to do as a estate agent, or rather as a property practitioner yourself, to be compliant with this piece of legislation as well as the regulations. But I'm going to try and sum it up for you as far as possible, and try and make the Act simple when it comes to its implementation at JPOMA and other property managers or property rental and sales companies in the country. I think as a sort of important segue, or rather a starting point, is that as much as Angela said, I do know all things property, the Act is incredibly new, number one. Number two, there's a lot of things that I am, or rather that the Act creates a gray area about, that the Property Practitioners Regulatory Authority, basically the new Estate Agency Affairs Board, needs to sort out themselves, or rather give directive to the property industry before I can really tell you this is exactly what they want by the specific section. Things that are included in this is processes of obtaining your qualification, because as you well know, in the previous piece of legislation, even though it wasn't actually in the previous piece of legislation, the Estate Agency Affairs Act, they had this process of a person going through their NQF4s and NQF5s, doing a log booking system, and then registering as an estate agent thereafter. The new Act, as much as it sort of speaks to that, it really makes things a lot simpler without giving further clarification. So what I mean by that is, in terms of the new Act, it would seem as if a person would no longer need to do something like an NQF4, NQF5, but they'll need to go through their CPD certification, and they'd also need to be under supervision of a property practitioner for a period of 6 months before they can actually go and write their PDEs. But the thing is, I can talk to that for about an hour, saying what I think the piece of legislation says and what I think the Property Practitioners Regulatory Authority will do. But at the end of the day, unfortunately, I can't give you further clarification on that, simply because the piece of legislation is not as forthcoming with that information. And what was dealt with in terms of the Estate Agency Affairs Board previously, and how they regulated their own internal processes for registrations versus what they're going to do now, is sort of really up in the air. So I hope, for everybody's sake, for my sake, for all of your sakes, within the next month or two, the Property Practitioners Regulatory Authority will actually give us further clarification or direction on how to become a property practitioner if you have not previously registered as an estate agent in the past. But you're more than welcome to ask me questions on that throughout the session today as well. So unfortunately, I had a set of slides, but they're TPN slides, so I can no longer use them. So I'm just going to speak to you today about the piece of legislation, sort of how it impacts you, etc. So the first starting point, when it comes to this piece of legislation is obviously looking at the purpose. Why have they done this? Why have they actually implemented the piece of legislation to regulate the property profession, or rather property professionals, or property practitioners, when we already had the Estate Agency Affairs Act in the past? The reason for that is because at the end of the day, they need to provide for further regulation of the property industry. Now, as we had with the Estate Agency Affairs Act, there were a number of people, professions that logged into that act very, very succinctly and very easily. Whereas what they've done with the Property Practitioners Act, they broadened the definition of property practitioner to include a lot of other bodies that did not actually, or rather professions that did not fall into the definition of an estate agent in terms of the previous act. And this is to provide for regulation of those specific parties. Because people like auctioneers, people who facilitated auctions, commercial property brokerages, so commercial estate agents, did not actually fall under the ambit of the Estate Agency Affairs Act, which now it does, which provides for regulation of those specific professions and other bodies that would fall under that. It was also there to promote the continuance of the Estate Agency Affairs Board. So you no longer have the Estate Agency Affairs Board, but they basically just gave it another name. The same people that sat on the EXCO, the same people that worked at the Estate Agency Affairs Board, is still working at the Estate Agency Affairs Board. We're just now calling it the Property Practitioners Regulatory Authority. They did a whole rebranding on that as well. With the Act, it also promotes further appointments on the specific board, because as you've got these new professions now entering into the property or the property sector, the Property Practitioners Act, they need to promote and appoint different parties who fall into different categories of businesses that is now going to be affected by this piece of legislation. It also promotes the transformation of the property sectors, specifically through a transformation fund and a transformation charter, but also it provides for granting of or the giving of grants to certain parties if they did fall under the previously disadvantaged categories, which is obviously a great thing, because if you look at the property sector at the moment, specifically estate agents, there hasn't been a lot of diversity that has been granted through the previous act, and not a lot of initiatives by the Estate Agency Affairs Board to try and rectify that scenario. So it's a great thing that they're actually trying to go and do this. It also provides further, or rather promotes, consumer protection, meaning that you've got pieces of the legislation currently that is regulating property practitioners, but also regulating the relationships between the consumer, the person purchasing the property, or the person selling the property, to the person renting the property, or the person leasing the property, to fall under some form of consumer protection as well. Even though you had the Consumer Protection Act, it just delved into this a little bit further, specifically having a look later at mandatory disclosure forms and how that also is going to impact you going forward in your processes. And then it obviously repealed the entire Estate Agency Affairs Act as well as the regulations there too, and created a new form for all of those pieces of legislation called the Property Practitioners Act and Property Practitioners Act regulations. So as a starting point, every estate agent that is registered as an estate agent currently can call themselves a property practitioner. They are technically registered with the Property Practitioners Regulatory Authority, but every single person that is a property practitioner will then, or falls under the new category of property practitioners in the definition, would need to be registered with the Property Practitioners Regulatory Authority before the 31st of October of this year. It's also important that any person that is not registered as a PP is currently not actually acting against the law. They would only need to be registered before the 31st of October, and they obviously need to take certain steps to be able to register. There's two different definitions of property practitioners herein. We're just talking about property practitioners, which are individuals, natural people working at a business, whereas you do also get a business property practitioner, which would be the business itself. For a business property practitioner, also obviously an FFC is required for that specific business. And to get that, they have further taken this a little bit further, saying that a business property practitioner would need to get something like a tax clearance certificate with SARS, as well as a valid BEE certificate. Now, also in terms of the legislation, I cannot tell you how far that BEE certificate goes, because the only thing that they say in the Act is a valid BEE certificate. So I'm not sure if a thing like a affidavit that parties did prior to this saying that they're not compliant with BEE because they can't be compliant because it's one person running the business, or it's a sole prop or whatever it might be that could only get an affidavit. I don't know how they're going to regulate that. But basically, as a business property practitioner, you'd need to have a valid BEE certificate as well as a valid tax clearance certificate to actually be able to register before the 31st of October. Whereas for individuals who are going to be property or who are property practitioners currently, they'll need a valid FFC, obviously, to continue going forward from the 31st of October. And to get that, you would need to have a valid tax clearance certificate as well as obviously have done your PDEs if it falls under the new category of how they're going to actually go through the authentication of property practitioners or estate agents. I wish I could speak to you more about that and tell you, no, you don't need to do your NQF4s or NQF5s. What I've told all the clients that have asked me about this is go on with the current process as you are currently busy doing it until they've changed it from the Property Practitioners Regulatory Authority side. Go on with the current process. Continue doing your NQFs. Continue doing what they've given you. Continue with your logbooking system until there's further clarification from the Property Practitioners Regulatory Authority from that side. Also, just to let you know, the Act obviously came into operation from the 1st of February. So a lot of the things regarding consumer protection, etc., that I'm going to be talking about later, what needs to change in lease agreements, marketing material, etc., already needed to have been implemented, whereas your registration as a property practitioner is only going to be from the 31st of October of this year. So like I said, the Act consists of the Act itself as well as the regulations. It's not actually a very long Act to get through. If you're more interested in that, I can obviously send you a link to a TPN summary of the Property Practitioners Act if you like to have a look at that. But if you do a simple Google search, you're going to get quite a nice summary of what's actually in that legislation. But like I said, we're going to be going through that today as well. So things that need to change currently from a property practitioner's perspective, as well as a business property practitioner's perspective, is actually pretty simple, and you can sum it up in a couple of ways. Number one, there's things that need to change from a business practice marketing perspective, and then there's things that need to change from an administration lease agreement, sale agreement perspective. So I'm going to split the two. We're first going to deal with what you need to change as a business when it comes to your marketing, and then we'll head into your agreements, what needs to change as well. So from a business perspective, from any person that is registered as an estate agency or a business property practitioner, your FFCs must be displayed at every single place of business. What I mean by that, and once again, there's not really been further clarification on this, but a place of business could even be something like a website, I believe. That's what the head of the CEO of the Property Practitioners Regulatory Authority said, is that websites could also be taken into consideration as a place of business. But as a physical place of business, the valid FFC of the actual business property practitioner and possibly of the individual property practitioners needs to be on display so that people can actually see that these parties have been registered with the Property Practitioners Regulatory Authority. That's your current FFCs. Prior to the 31st of October, you can still use your normal FFCs that the EAB processed for you. So that's when it comes to your actual place of business, your FFCs, it needs to be in display so that people can actually make copies of that. Secondly, marketing material. Now, marketing material, once again, isn't defined. So a marketing material could be something like a pamphlet, It could even be an advertisement that's been placed on private property or property 24 possibly. So it's marketing material, it's stuff that you're actually giving out to the general public. What needs to be displayed on that specific marketing material is that the estate agent is registered, or rather the property practitioner is registered with the property practitioner's regulatory authority. So it needs to contain that specific warranty, that specific sentence that says that the property practitioner is actually registered with the property practitioner's regulatory authority, which is an important one. So that is a marketing change that actually needs to occur on any type of pamphlets or any type of marketing material that you do go and send out. So that's very short, actually, when it comes to the marketing aspect of the business and what they need to actually go and change. Really, really simple. Valid FFCs must be on display at every place of business, and marketing material must now contain this specific provision that relates to the registration with the property practitioner's regulatory authority. Clients have asked me this as well, but what if they're not registered with the PPRA? They are registered with the PPRA. If you previously registered with the Estate Agency Affairs Board, you are currently registered with the Property Practitioners Regulatory Authority. If you are not yet, then obviously you need to go through the processes that I did delve into a little bit in the previous section. But once again, you need to go and submit all your documentation to the PPRA before the 31st of October. You need to ensure that you've gone through the processes that they've already established, whether those are the exemptions, whether they're the logbooking system, NQF4s and NQF5s. You need to get further direction from them. But from the business property practitioner side, that's basically the two things that you're looking at. Is your FFCs being on display and that marketing condition included in any marketing material. From an agreement perspective, and this is where things get incredibly important, is from the agreement itself. Because in terms of the Act and the new regulations, it specifically dictates that people can obviously be investigated by the PPRA. They can come into a place of business to make copies of documentation without a warrant. All of these things have been included. It obviously also includes sanctions and penalties that can occur if you're not in compliance with the Act. One of the interesting things that comes into play over there is that if you've been paid a commission and you are not registered as a property practitioner, you cannot keep that commission. It's actually supposed to be paid back to the PPRA, and they'll determine how that money is going to be categorized or where that money is actually going to go. From an agreement perspective, two things that's vitally important. Yes, you can go and change in your documentation that it now refers to property practitioner rather than estate agent, but it is really not actually necessary. The reason for that is the Act doesn't make it obligatory to go and do something like that. At the end of the day, you're still an estate agent, even though you're calling yourself a property practitioner. Now, the regulations even refer to things like managing agents, estate agents, etc. But what is very important from an agreement perspective is that you must have a mandatory disclosure form, which I'm going to go into more detail in about 5 minutes or so, but also that you need to include a clause in your agreement that says that the property practitioner warrants the validity of the Fidelity Fund certificate as at the date of signature of that document. So that means that in the actual lease agreement, in the sale contract, in the mandate agreement with the owner of the property, whether that's a mandate to sell, whether that's a mandate to rent out the property, there must be a clause included in that actual contract that says that the property practitioner warrants the validity of the Fidelity Fund certificate as at the date of signature of that agreement. And that's really the only changes that need to occur in terms of your contract. So number one, the mandatory disclosure form must form part of that. I'm going to delve a lot into that in the next 5 minutes. But in terms of the actual lease agreement, the sale contract, any contract that's entered into between the parties, the property practitioner must warrant the validity of the Fidelity Fund certificate. Very short sentence, can just be incorporated into any contract that you do with an owner or that you do with an individual tenant if you're actually signing the lease agreements on behalf of the owner, etc. Moving into mandatory disclosure forms and why these things are so incredibly important. So let's talk about the repercussions of not doing so first. So say, for example, a property practitioner does a lease agreement or a sale contract or facilitates that transaction between the parties, and they don't have a mandatory disclosure form signed by the owner, and it doesn't form part of that contract. The property practitioner could actually be held liable for the damages, the defects, anything on that property that was not indicated in that mandatory disclosure form that the purchaser of the property or the tenant would have a claim against the actual owner of the property could be passed on to the individual or the business property practitioner if there is no mandatory disclosure form signed. So that is so vitally important that mandatory disclosure forms get signed because you're just opening yourself up for liability when it comes to that. The mandatory disclosure form is actually a template directly from the regulations. They've actually drafted a template that you can go and have a look at that says, this is a mandatory disclosure form, this is what needs to be included, the details of the parties, etc. And then it's basically a defects list, like what you get in a rental scenario with an incoming inspection. This mandatory disclosure form, however, does not take the function of an incoming inspection. So you're supposed to do the mandatory disclosure form as well as actually your incoming inspection on rentals. That incoming inspection doesn't fall away. That's still part of the Rental Housing Act and still needs to be complied with. Whereas the mandatory disclosure form is a document signed by the actual owner of the property prior to the property practitioner entering into a mandate with that specific owner. So that means that a document, that mandatory disclosure form, must actually be signed by the owner prior to a mandate agreement being entered into. That document then needs to form part of the mandate and form part of the actual lease agreement or form part of the sales contract. So it is advisable that this is obviously spoken to in the lease agreement. TPN's documentation, when I was still busy drafting these documents, we amended it to include the mandatory disclosure form as part of the documents already and indicated that the estate agent must tick yes or no whether the document has actually been completed or not, which isn't a bad idea. At the end of the day, it is the owner's responsibility to actually go and complete this. However, the property practitioner must ensure that it is completed by the actual owner of the premises. So then that mandatory disclosure form must be signed. It must be attached to the mandate agreement. It must be attached to the lease or the OTP. And then every single party that is part of the transaction must actually go and sign that document as well. So the owner is going to sign it when they do the mandate. Then that document gets passed through. It forms part of the mandate. The property practitioner can sign it then. And then once the lease agreement has been concluded, or this OTP has been concluded, then the purchaser of the property or the tenant, prospective tenant, must actually go and sign that document as well. And then it forms part of the actual lease contract. So mandatory disclosure forms is one of those things I've been harping on for the last 2 months about. It is not one of those things that you can get away with. You must do that for every single contract that you go and do. It is not for multiple properties. It is property specific. So it needs to be done on every single property that is going to be rented out or sold. Must have a mandatory disclosure form unless the property practitioner wants to open themselves up for a lot of liability at the end of the day, taking responsibility for damages and defects on the property that shouldn't actually be their responsibility to go and do. But you most certainly need to do so. There are exclusions when it comes to this, in that certain portions of the Act, a property practitioner can apply to have them exempted from that. Things like having a trust account, because one of the changes in terms of the piece of legislation is also that property practitioners no longer need to have a trust account if trust money is not being transferred directly to them. So situations that could occur in a way with this is, say, for example, a rental company using somebody like a property management system. PayProp keeps the deposit on behalf of the actual property practitioner, or rather on behalf of the tenant. That money is not kept in trust by the actual property practitioner itself. It's kept in trust by the business property practitioner. PayProp is also a property management system. Or even in instances of a sale where the money is being held by the attorney, or rather the conveyancer, rather than being transferred into the trust account of the property practitioner. Then you could apply to have your trust account exempted. You could also apply to have certain provisions, sections of the Act not be applicable to your specific business property practitioner. But you're not going to get away with the mandatory disclosure forms. It's consumer protection, as we've had with the last, let's call it 2 years of legislation changes. As we all know, we got amendments to the Promotion of Access to Information Act. We got the implementation of the of POPI, or the Protection of Personal Information Act. We had the Consumer Protection Act getting more regulations involved. So you're not going to get away with not having a mandatory disclosure form. It's probably the most important thing that I can note today is the mandatory disclosure form needs to be done, and it needed to have been done from the 1st of February already. So for any new deals, most certainly you need to go and do so. Okay. Then at the end of the day, your Fidelity Fund certificates, and this is sort of an important thing to note right at the end, is that your FFCs is going to be valid for a period of 3 years rather than the current 1 year as they've had in the past. Your FFCs are also not going to be designation or company specific. So an individual property practitioner who, say, for example, has been working at Just Property and now wants to move to Rawson, wouldn't need to get a new FFC through the Property Practitioners Regulatory Authority to go and do so, because that property practitioner is registered as a property practitioner, not through Just Property, but they're registered as a property practitioner through their own, by their own, and through the Property Practitioners Regulatory Authority as a natural person. And also, it's not going to be designation specific. So let's say, for example, a person is a property manager, they're a sales agent, they're a rental agent, or they've been registered as a full status estate agent in the past. That FFC is not going to display that. It is not going to be designation specific. So your FFCs is actually going to be a period of 3 years. However, you still need to go and submit things like your trust account audits, your normal business account audits every single year. You also need to go and obviously go and submit your tax clearance certificates, BE certificates, etc., for you to maintain your status as a business property practitioner. However, as an individual, you'll only need to do so every 3 years. It's going to be valid for a period of 3 years. If they obviously ask you to go and submit different documentation every single year, say, for example, your CPD verifications, all of that, then that's also going to fit into that, and that will be before the 31st of October of each and every single year. With your CPD verifications, it is going to be run a little bit differently, since the Estate Agency Affairs Board no longer has a monopoly on verified CPD points. You can actually go and register a company that can do CPD verifications on behalf of the Estate Agency Affairs Board, or rather Property Practitioners Regulatory Authority. How that is going to work is you need to do a, yeah, it is that way. You need to do a 18 verified CPD points per 3-year cycle. So that basically means 6 points per year, depending on the type of category or business that you're currently in. But like I said, it's so difficult to talk about all of these things. I can tell you what the piece of legislation says, but at the end of the day, I don't know how they're going to regulate this, specifically newer companies coming on board and trying to create their own verified CPD systems. It could get pretty interesting over the next year or so. And then at the end of the day, just remember what I said. The most important concepts for today and the takeaways from today is that the mandatory disclosure forms for any contracts that you sign is absolutely, absolutely vital. Can't get past that. It needs to be done. And then also the changes to the marketing material and the lease agreements can be done currently as is. If you haven't yet started as a business with a BE certification process, it's probably one of the first stopping points that you need to go and do now. And also similarly, if previously your estate agent or your property practitioner trust accounts were not audited by an auditor, that needs to start happening now, so that you can actually go and submit those documents before the 31st of October. Excellent, Angela. That brings me to the end of my session for today. It's quite a short summation, but I'm sure we're going to have a lot of questions. So I'm going to open up the floor right now to any person that might have a question for me. You're more than welcome to ask those right now.
Great. Wow, Peter, that was amazing. Thank you. In a nutshell, you did it in half an hour. Well done.
Yeah. Good. Okay. So sometimes you make something very complex short because at the end of the day, I mean, we can have a discussion just on who's exempted from audits for half an hour, but it's really not going to help you having that discussion. I think the most important stuff is what can be changed now, what must be changed now, and how do you go about ensuring sort of your compliance prior to the 31st of October. Because all of the different sections regarding consumer protection is supposed to come into play now, whereas the FFC verifications is only 31st of October. So I think those are sort of the important points when it comes to what a business property practitioner or what an individual should be doing right now.
Yeah. And maybe you could just explain what have they put into the act what the penalties will be for not complying?
They have, but I mean, it is so far reaching, because the thing is, let's say, for example, it's like an up to and a fine amount that hasn't been declared yet, but usually it's they input something like a fine for non-compliance would be something like 10 years in imprisonment for a period not longer than let's say, for example, 5 years. Usually they include that in the actual legislation. But I think the important stopping point there is that's almost never going to happen. It is sort of like poppy and poppy compliance. Now, I can tell you right now, 70% of the property industry is not being poppy compliant. We know that because TPN put out a poppy compliance portal. We asked the questions of how many people is busy doing what, have you done personal information, impact assessments, etc. 70% of people said they hadn't done so yet. The fine in terms of that piece of legislation is like 10 years imprisonment, something crazy. Wow. But the thing is, that's not going to happen. It depends on the breach. It depends on what you've done wrong. Now, let's say, for example, as a property practitioner or a business property practitioner, you haven't included things in your marketing material. If you don't go and include this clause that it says needs to be included in lease agreements or sale agreements, they're going to send you a compliance notice. They're going to tell you, go and do this. You're going to go and do it, and they're not going to do anything worse than that. But a mandatory disclosure form, on the other hand, or not being registered as a property practitioner, has an almost immediate consequence. Because the mandatory disclosure form, if you don't do one, you get caught out that you haven't done one. Immediately, that liability gets transferred on the property practitioner. Whereas if you have not registered as a property practitioner, you get caught out, you make your commission, you've got to pay back all that money. So that's like immediate repercussions. So I think that's rather a focal point. But I mean, the maximum fines, maximum penalties, and maximum times imprisonment, it will really be only something if you've practiced for the last, or you're going to practice for the next 3 years, not being registered, making all this money. They're going to send you compliance notices. You're not going to comply with them. Then that sort of thing will kick into play. But I think the mandatory disclosure form is like immediate repercussion type stuff. So that's definitely a focal. Yeah. Okay,
cool. We've got a hand up from Peter Dean.
Yes, please go.
Hi there, Peter. Thank you for this presentation. It's been most informative. But I work in the sort of inner city retail where we enter into lease agreements with tenants directly as the property owner. Okay. How would this legislation affect the way that we process those leases?
So let me just ask you a couple of questions here, Peter. So you are the actual owner of the property, or rather the company that you work for is the owner of the property, correct?
Correct.
Okay. And you're only renting out your own properties?
Yeah.
Okay. So there is two differing opinions on this. I'm going to tell you what mine is, and then I'm going to tell you what I have seen in the industry and the opinion specifically from the Property Practitioners Regulatory Authority on the first day that they did the webinar. My opinion on this is, if you're renting out your own properties, you're not earning a commission or a remuneration. It's purely an employee that is renting out the company's own properties on behalf of the company. A landlord cannot be considered to be a property practitioner, or rather a business property practitioner. And thus, it would not make sense that if the company is not a business property practitioner, that the individuals would need FFCs and to be registered as a property practitioner as well. That's my own interpretation. There's definitions that speak a little bit differently to this when it comes to property development and development companies selling their own properties, where it might be a possibility that they could be considered property practitioners. But once again, we need further direction from the Property Practitioners Regulatory Authority. There has been a differing opinion that says that any person who manages, facilitates, or does administration, so basically a office manager, property manager, etc., would fall under the definition of a property practitioner and would need to be registered. But I cannot see how they're going to do that. It would not make sense to me, because if the business is not a business property practitioner, because they're not running the business of a property practitioner, then how can you force individuals to be property practitioners actually working at that company? So my opinion to you, Peter, and please don't take this as Peter Mennen said, this is succinct, this is 100%, we don't need to do this. You need to go and follow up with the Property Practitioners Regulatory Authority. But from my perspective, my opinion would be that nobody in that company needs to be registered, and the company wouldn't need to be registered as a property practitioner. So none of this would actually apply to you.
All right, perfect. Thank you so much for that, man.
Pleasure. I see Taryn has her hand up. Sorry, Angela.
Oh, that was on mute. Carry on.
Hi, good morning, everyone. Hi, Peter. Taryn here from Trafalgar.
Hi, Taryn.
Peter, so yes. Two questions. First one about, the FFCs. So I know you said continue as normal and all of that, but, wouldn't it make sense? And I know it's not an answer for you to give, but just sort of your advice. We know that there's staff, there's different scenarios, and a company as big as Trafalgar, there's certainly different scenarios.
Yes.
We have staff that have completed the logbook and are just waiting to write the PDE 4. So, we've said, well, go ahead and do that because you've come this far already. But then we have staff that are still very much in the process of the logbook, which is quite early. And,
yes.
31 October is around the corner. So, we kind of stuck in a place, do we continue with the logbook only for there to be changes thereafter, and that would have made it a waste of time given the timeline? If this was last year, we would have said, do it because then there's enough time to do the PDE. But given
yes.
sort of the timeline, which is less than 6 months, one would think, because you'd need to be completed with the logbook by June, and then you register for PDE, which is only for next year. So those that are writing the PDE for this year would be around, I think, May, June. So, we were just thinking that, is it something that should continue for those that are still very much in the early stages, or should we pend it to see what the Property Practitioners Act dictates, and then, take it from there? That's sort of question number one. Yeah. I'll let you answer that before I go to the second one.
Perfect. Thanks, Taryn. Taryn, so I'm going to do it in this way, rather. Say, for example, I was in their shoes, in the individual estate agent who is currently busy doing everything in their power to become a registered agent. I would carry on with that process. If it was my own, if it was for myself, and I haven't been given further directive from the Property Practitioners Regulatory Authority, I would carry on as is. I would carry on with doing my logbook, with writing the exams that I'm supposed to be writing. Even if I'm still busy with my NQF4s and NQF5s, I'd still complete it. The reason being is that they're not going to say, well, now you need to do something extra to become a property practitioner. They're lowering the bar. One of the comments that was made on the private property webinar was that, and I'm sorry for this, please don't get angry at me about this, but they said it is as if you had this like full estate agent and now you've got estate agent light when it comes to with the new regulations and with the new act. They are not going to increase what a person needs to do to be registered. They're going to decrease. So I would rather carry on with the normal process, because then you know that you're going to be qualified in full. And if you can register then before the 31st of October, that application needs to be sent through. Even if they say before that you can write your PDEs, let's say for example in September, so that you can register in October, you've already done the majority of the work. Or let's say you've done more work than what is actually required in terms of the new legislation. So I'd rather carry on with the process, make sure that everybody is doing and carrying on with what they're currently busy doing. And then once further direction has been garnered from the PPRA, then you can go, okay, we can stop this, we can stop that, we can only go and do this, we only need to go and do this. But don't stop any processes now, because at the end of the day, they could tell us only next year, February, what they want from us. Everybody was sort of caught a little bit unawares with this piece of legislation. It happened like this. They were obviously aware that because they did their name changes and rebranding, but the entire property industry was not. So I would rather carry on with the normal processes that you're currently busy doing. And then if they go and changes, at least you know that you've done more than what is actually required. And you'll be able to sort of go and do what is required of you by them, because you've done more than what the current piece of legislation actually says. So I would tell all of those people, carry on with what you're busy doing. Don't change anything up. I am sure that when I start, let's be diplomatic about this, I will be in direct contact with the PPRA about this, because they need to give direction. We can't carry on just not knowing what's going on here. But for the moment, please carry on as is.
Okay, perfect. Thanks, Peter. And then this is the last question about the mandatory disclosure forms. So this would only apply to new leases or new OTP since 1 Feb. If it's a tenant that's existing in the unit and a lease agreement is already in play, we don't need to draft sort of an addendum and include this disclosure, right?
That's correct. Upon renewal, yes, you will need to do so, because a renewal is basically a new contract. But any contract that is currently ongoing in its fixed term period, so not month-to-month agreements, because they renew each and every single month, but contracts that are actually in its fixed term period, you will not need to do so right now. The piece of legislation we call it retroactive application, whereas it applies to the past. This is not so. It only applies to the future. So if the contract was entered into prior to, or the mandate and the lease agreement was entered into prior to the 1st of February, don't worry about it now. It's only upon the renewal that you need to go and do so.
Okay, and then just my last sort of comment on the same topic. If we had to take on, so I know you said at the point of securing a mandate is when we should get this mandatory disclosure. So, I mean, if you're selling an individual unit, it's sort of easy and it makes sense. And if it's a residential let, it's easy and it makes sense. But let's look at it if it's a building, if it's a residential building or if it's a commercial building, multiple units. Are we then saying an inspection should be done with the landlord upon take on of management of those buildings and sort of ironing out per unit, what the sort of maintenance or the defects are in order to have that disclosure form completed? Or can it be done on a pre-let basis? You take on the building and as you let that unit, you sort of get the disclosure form sort of completed at that stage. Because I mean, one would think that if you had to do sort of 50 units upfront with the landlord, it sort of doesn't make, it's a lot and it doesn't make sense. And, a lot could happen down the line as well. What if it takes us 6 months to let a unit? But if you kind of do it on a pre-let basis and, at the point of letting that unit, you get the disclosure form completed along with the landlord, which could work in tandem with an ingoing inspection. or an inspection, maybe not an ingoing inspection, but at a point of inspection, would that be your recommendation, or what would be your recommendation?
John, I love your question, because you ask what would be my recommendation. Okay, my recommendation, and yeah, let's do that. My recommendation would be to make it the most practical for the business, because like you said, if it's 6 months down the line and you're renting out this unit and the disclosure form or the mandatory disclosure form is now incorrect because of 6 months of little maintenance or whatever it might be, then that is not going to be displayed. But at least it's not your problem. At least it's not the property practitioner's problem. But if you want everything to be correct, yes, you're going to do it prior to leasing out the property. But what I can tell you from the legislation is this is pretty black and white. It states that you cannot enter into a mandate agreement with an owner of a property unless that mandatory disclosure form has been completed. So it needs to be done at mandate level once the mandate has been granted by the party.
Okay.
But let's go back to my previous discussion on the penalties of non-compliance. Is that at the end of the day, the property practitioner's regulatory authority, if you go and do it prior to the unit being let out, you're being compliant, because now this document forms part of your mandate and forms part of your lease agreement, and nobody's going to be any wiser. They're not going to come back to you in that 6-month period and say, but you haven't done a mandatory disclosure form, unless they do some form of investigation at the property practitioner, and you're very unlucky and it falls within that 6-month period that you were supposed to do it. The risks aren't very high. That's what I'm trying to sort of press for here. But the legislation, if you read it restrictively, it needs to be done at mandate phase. So prior to you entering into the mandate.
Okay, no, perfect. Thanks, Peter, and we'll chat to you further down the line. Thank you.
And your pleasure, Tara.
Great, thanks. Next, we've got Mark Tates.
Hi there. Just following up on Peter's question, if that sort of in-house management takes place via another in-house entity, common shareholding, would that exemption still apply to not having to register?
Is that company being granted a remuneration or commission package for every property that they're busy renting out?
There is a collection commission, but the companies that own the properties receive the rentals and pay the expenses directly. Yeah. So it's just a structure where the buildings are owned by separate entities to the management entity. I mean, there are some differing shareholders, but the shareholding is pretty common, and there's no trust money as such, because it all goes into the owner of the property's account.
So first of all, I think that the management entity would be exempt from having a trust account, number one. But in saying that, they would need to be registered as property practitioners, because they are receiving commission for the renting out of properties from a different entity. If it was the same entity that was only busy doing their own management, my answer would have been different. But here you've got a situation where, as a company is busy purporting themselves to be a managing agency, and if that is the case, that they're purporting to be a managing agency, they would still need to be registered as PPs. But you'd have less of sort of a administrative burden on you, because you wouldn't need to audit your trust accounts, etc. But you'd still need to be registered as a business property practitioner, most probably. It is one of those, Mark, that I would rather have you confirm that with the property practitioner's regulatory authority. But it would seem to me as if my opinion on that would be that that entity would need to be registered, yes.
Okay, thanks.
Sorry about that. It wasn't the answer you wanted.
No.
No
one wants to know that they've got to do extra work.
No, most certainly not. No, I think we're all over it. Like, I think, after this last 2 years of having to implement PIA and POPI and CPA, and this now, yeah, it does sort of feel like everything's being overly regulated, but yeah, you sort of got to do what you got to do, hey?
Exactly. So I don't see any more questions or hands up, and we are coming to the end of our hour. So your timing was perfect. You said you would do it all in an hour, and you did. So well done. So I don't know if in your new role you'll be able to come back and update us of any changes, and please stay in contact with us. We would definitely like to.
Will most certainly be able to do so, yes.
Okay.
In my
Okay,
anytime.
So we'll have you back. So thank you so much for your time and for assisting us with this, and good luck with your new adventure.
Thank you very much. Very exciting. Everybody have a fantastic day further. Thanks for joining us, and I'll see you all very soon. Thanks, Angela.
Okay, thank you. Bye.